Greetings. I hope everybody is doing well and this finds you well and in good spirit. Today we're covering the Hobbs Act. Generally, the Hobbs Act prohibits actual or attempted robbery or extortion affecting interstate or foreign commerce in any way or degree. Section 1951 also prescribes conspiracy to commit robbery or extortion without reference to the conspiracy statute at Title 18 USC subsection 371. The statutory prohibition on physical violence to any person or property in furtherance of a plan or purpose to do anything in violation of this section is confined to violence for the purpose of committing robbery or extortion. United States versus Franks 511 F period 2D 25, 31, Sixth Circuit Court, 1975. Rejecting the view that the statute prescribes all physical violence obstructing, delaying, or affecting commerce as contrasted with violence designed to accumulate in robbery or extortion. Ladies and gentlemen, the Hobbs Act can be used to your benefit when being accosted by somebody clearly violating their oath in order to make revenue, generate securities for their principal. The extortion offense reach both the obtaining of property under color of official right. All right. Who colored them with the law, ladies and gentlemen? Did you color them with the law? Who colored them with the law? And remember, if we're not doing things in good faith, then we're acting in a colorable manner. And those two never commingle. It's like the public and the private. They just don't commingle. They don't interchange. So under color of official right, by public official, and he obtains and the obtaining of property by private actors with victims' consent, induced by wrongful use of actual or threatened force, violence, or fear, including fear of economic harm. See this manual at 2405 and Evans versus United States, 504 U.S. 255, 265, 112 S period CT period 1181, 1188, 1992. Only a private individual's extortion of property by the wrongful use of force, violence, or fear requires that the victim's consent be induced by these means. Extortion of property under color of official right does not require that the public official take steps to induce the extortion payment. All right? Although the Hobbs Act was enacted in 1946 to combat racketeering and labor management disputes, the extortion statute is frequently used in connection with cases involving public corruption, commercial disputes, and corruption directed at members of the labor unions. Proof of racketeering as an element of Hobbs Act offense is not required. United States versus Colbert, 435 U.S. 371, 98 S period CT period 1112, 1978. However, a violation of the Hobbs Act may be part of a pattern of racketeering activity for purposes of prosecution under the Racketeer Influenced and Corrupt Organization RICO statute, Title 18, USC, subsection 1961, ET, SEQ, period. In order to prove a violation of Hobbs Act extortion by wrongful use of actual or threatened force, violence, or fear, the following questions must be answered affirmatively. Did the defendant induce or attempt to induce the victim to give up property or property rights? Property has been held to be any valuable right considered as a source of wealth. United States versus Tropino, Tropino, 418 F period 2D 1069, 1075 2D circuit Second Circuit 1969. The right to solicit garbage collection customers. Property includes the right of commercial victims to conduct their business. See United States versus Zemeck, Zemek 634 F period 3D 1159 1174 Ninth Circuit 1980. The right to make business decisions and to solicit businesses free from wrongful coercion and cited cases. It also includes the statutory right of uniformed members to democratically participate in union affairs. See United States versus Debs, 949 F period 2D 199, 201, Sixth Circuit 1991. The right to support candidates for union office. United States versus Teamsters Local 560, 550 F period SUPP period 511, 513 through 14 in period D period in period J period 1982. Rights guaranteed union members by the Labor Management Reporting and Disclosure Act, Title 29 U.S.C. subsection 411. Did the defendant use or attempt to use the victim's reasonable fear of physical injury or economic harm in order to induce the victim's consent to give up the property? Are they stealing your automobile on the side of the road? Are they using intimidation tactics, knowing full on well that if you miss a day of work, you're going to spend the next week trying to make up that lost revenue? Are they using these tactics against you unlawfully, illegally, to participate in a scheme that generates money for their principal, otherwise identified as a RICO Act or RICO violation? A defendant need not create the fear of injury or harm which exploits to induce the victim to give up property. See United States versus Dahone. Now, they're wanting you to sign an instrument on the side of the road. Is your signature your property? That's what you need to know. Are the things that you constantly freely give up property in the eyes of the law? Is your retina scan property? Are your fingerprints property? Is your DNA property? Is saliva property? Is urine property? You need to really start to evaluate what property is and what rights are. Okay? Rights are property, and without property, you don't have any rights. See United States versus Duhan, 565 F period 2D 345, 349 and 351, Fifth Circuit 1978. Offer by employer to pay union officials for labor peace held to be simply planning for the inevitable demand for money by the union officials under the circumstances. United States versus Gigante, Gigante, 39 F period 3D 42, 49, Second Circuit 1994. Give me 1 second. Hey, get in here. What are you doing? Raising all kinds of hell in the neighborhood. All right. Okay. Where were we at here? Simply planning for inevitable demand for money. The union officials under the circumstances, United States versus Gigante, 39 F period 3D 42, 49, Second Circuit 1994. Vacated on other grounds and superseded in part on denial of REH, G, 94 F period 3D 53, Second Circuit 1996, causing some businesses to refuse operations with the victim sufficiently induced the victim's consent to give up property consisting of right to contract freely, which is protected. It's protected. It's not a constitutional right, people. It's a protected right by the Constitution. Article 1, Section 10 gives you the unalienable right. It's contract at will, and it also gives you the unalienable, well, it doesn't give you anything. It secures and protects your unalienable right to contract at will. Okay, we need to start really speaking correctly because everything has to do with language. All right, the means of conveyance is language, and language is where you get in trouble. They're putting spells on you with spelling, and you're not recognizing it because you have a second grade reading education level. And I don't care if you graduated college, most of you don't have a reading education level above sixth grade. That's a fact. All right. So be very careful with the words you use. Start studying the etymology of the words because they have a lot of power. Remember, the pen is mightier than the sword. But what does the pen lay to paper? Ink, right? But it's the mind that lays down the wordsmithing, that creates the contract, that binds these people and holds their feet to the fire. It's about the words that are being used and what they mean when they are utilized. All right? To refuse operation with victims sufficiently induced, the victim's consent to give up their property, consisting of a right to contract freely with other businesses, as long as there were other businesses beyond defendant's control with whom the victim could do business. Moreover, attempted extortion may include an attempt to instill fear in a federal agent conducting a covert investigation or a defendant made of unusually stern stuff. See United States versus Gambino, 566 F2D 414, 419, Second Circuit, 1977. Argument that FBI agent pretending to be extortion victim could not be placed in fear. It is not a defense to attempted extortion of the agent. See also United States versus Ward, an attempt to instill fear induced a demand for money from a victim who knew that the defendant was only pretending to be a federal undercover agent when he threatened the victim with prosecution unless money was paid. However, the payment of the money is response to a commercial bribe solicitation. That is, under circumstances where the defendant does not threaten the victim with economic harm, but only offers economic assistance in return for payment to which the defendant is not entitled, is not sufficient to prove extortion by fear of economic loss. United States versus Campo, 817 F period 2D 947, 951 through 52, Second Circuit Court, 1987. Solicitation of money from job applications by persons having no inducement by fear, but see United States versus Blayton, 793 F period 2D 1553, 1558, 11th Circuit, 1986. Inducement by fear was proven by the defendant's solicitation of the labor consulting contract to help the employer stop outside union organization when the solicitation was accompanied by defendant's threat to form another union and begin organizing employees if the consulting contract was not accepted. Did the defendant's conduct actually or potentially obstruct, delay, or affect interstate or foreign commerce in any realistic way or degree? The Hobbs Act regulates extortion and robbery, which Congress has determined has a substantial effect on interstate and foreign commerce by reason of their repetition and aggregated effect on the economy. Therefore, the prescribed offenses fall within the category of crimes based on the Commerce Clause, whose de minimis charter of individual instances arising under the statutes is of no consequence. United States versus Bolton, 10th Circuit Court, 1995. Holding Hobbs Act convictions for robbery whose proceeds the defendant would have used to purchase products in interstate commerce, quoting the United States versus Lopez, and that was in 1995. Material in the brackets added. See also United States versus Atchison, Atcheson, robbery of out-of-state credit and ATM cards. United States versus Farmer, Robbery of commercial businesses, United States versus Stillo, is 1995 Seventh Circuit. Hobbs Act violations may be supported by proof of a direct effect on the channels or instrumentalities of interstate or foreign commerce, as for example, where the threatened conduct would result in the interruption of the interstate movement of goods or labor. See United States versus Taylor, 92 F period 3D 1313, 1333, Second Circuit Court, 1996. Extortion of money, unwanted labor, and subcontracts on construction projects by threatened shutdowns and labor unrest. United States versus Hagen, 68 F period 2D 1127, 1130 through 31, Ninth Circuit, 1982. Robbery of the three undocumented alien farm workers while they were traveling from Mexico to the United States in search of work. United States versus Capo, CAPO, 791 F period 2D 1054, 1067 through 68, Second Circuit, 1986. Vacated on other grounds, 817 F period 2D 947, Second Circuit, 1987. Scheme to extort local job applicants had a potential effect on interstate applications who might otherwise be hired. Indirect effect on such commerce are also sufficient. Indirect effects on such commerce are also insufficient, as for example, where the obtaining of property and resulting depletion of the victim's assets decrease the victim's ability to make future expenditures for items in interstate commerce. Taylor, Supra, depletion of contractors as assets. However, the Seventh Circuit has distinguished Hobbs Act cases involving depletion of a business assets from those involving the depletion of an individual employee's assets, which the court has ruled are not as likely to satisfy the jurisdictional requirements of the Hobbs Act. United States versus Matson, 671 F period 2D 1020, 7th Circuit, 1982. United States versus Boulahanis, Boulahanis, 677 F period 2D 586, 590, 7th Circuit, 1982. Other circuits have agreed where the extortion or robbery of an individual has only an attenuature or speculative effect on some entity or group of individuals engaged in interstate commerce, thereby diminishing the realistic probability that such commerce will be affected. See United States versus Collins, 40 F period 3D 95 100, 5th Circuit, 1994. Convictions for robbery or of a computer company employee reserved on grounds that theft of the victim's automobile with cellular phone had an insufficient effect on his employer's business. United States versus Quigley, 53 F period 3D 909, 8th Circuit, 1995. Holding the acquittal following guilty verdict of defendants who beat and robbed two individuals en route to buy beer at a liquor store. Was the defendant actual or threatened use of force, violence, of fear wrongful? Generally, the extortionate obtaining of the property by the wrongful use of actual or threatened force or violence is a commercial dispute, requires proof of the defendant's intent to induce the victim to give up property. No additional proof is required that the defendant was not entitled to such property, or that he knew he had no claim to the property which he sought to obtain. See United States versus Agnes, Agnes, 581 F period sub period 462 ED, Pennsylvania, 1984. Rejecting claim of right defense to defendant use of violence to withdraw property from a business partnership. However, the Supreme Court has recognized a claim of right defense to the Hobbs extortion and labor management disputes. In 1973 decision, the court reserved the conviction of union member defendants who had used violence against an employer's property during an otherwise legitimate economic labor strike in order to achieve legitimate union objectives. such as high wages in return for genuine service which the employer seeks. United States versus Enomons, Enmons. So anyway, this is the Hobbs Act, but I'm not done with you guys yet. I want to get to the meat and potatoes of this. All right, that was extortion by force, violence, and fear. We go even further into the Hobbs Act, and now we're going to go into extortion by color of right. All right. In addition to the wrongful use of actual or threatened force, violence, or fear, the Hobbs Act, Title 18 U.S.C. subsection 1951, defines extortion in the terms of the obtaining of property from another with his consent under color of official right. Color of official right, which means it's not lawful, ladies and gentlemen. It's only made semi-quasi-legal because people don't challenge it. And if you accept it, then no harm, no foul, right? So under color of official right. In fact, the under color of official right aspect of the Hobbs Act derives from the common law meaning of extortion, as the Supreme Court explained in a recent opinion regarding the Hobbs Act. At common law, extortion was an offense committed by a public official who took by color of his office money that was not due to him for the performance of his official duties. Extortion by the public officials was the rough equivalent of what we would now describe as taking a bribe. Evans versus United States, 504 U.S. 255 in 1992. In order to show a violation of the Hobbs Act under this provision, the Supreme Court recently held that the government need only show that a public official has obtained a payment to which he was not entitled to, knowing that the payment was made in return for official acts. While the definition of extortion under the Hobbs Act with regard to force, violence, or fear require the obtaining of property from another with his consent induced by the means. The under color of official right provision does not require that the public official take steps to induce the exoneration payment. It can be said that the coercion element is provided by the public office itself. Evans versus United States, 504 U.S. 255 in 1992. The United States versus, I'm not even going to try and pronounce it, MARGIOTTA, 688 F period 2D 108, 130, Second Circuit Court, 1982. Cert denied. 461 U.S. 913, 1983. The public officer misuse of his office supplies the necessary element of coercion. Ladies, threat, duress, and coercion still applies to these bad actors, all right? The fact that they're not registered with the Foreign Registration Act of 1938, the fact that they can't show you who colored them with authority, they can't provide you 3 forms of ID, or either they can and they won't. And there's reasons for it, because these lawyers have these people trained in such a way not to give up vital information that could find them in a private administrative process, causing them to lose everything in their life they've ever thought they owned. Okay? And so you really have to start to think about how law enforcement, policy enforcers is what they really are, revenue generators or revenue collectors, how they're really being trained. Because it has nothing to do with justice and more to do with just us. And I'm not talking about we the people. I'm talking about lining the pockets of lawyers. Without controversy, ladies and gentlemen, these lawyers literally don't have a job. You know, I talk to people all the time, and I said, you know, all you got to do to stop these constant bickering back and forth between your ex-esposa and yourself is just start telling your lawyers you don't have any more money. They'll stop having these mediation meetings as soon as they're not going to get their $350 every time they go and have a 15-minute bullshit meeting with you. They'll stop performing. They'll stop dragging out the court cases. You guys are allowing them to do it by creating controversy that otherwise doesn't exist because you guys aren't adult enough, well, let me see this, man and woman enough to just handle your affairs on your own accord. You were man and woman enough to consummate a relationship and to create little ones and all that stuff, and then all of a sudden you act like 2-year-old toddlers when you're no longer getting along and you separate from one another. Instead of handling your affairs as a man and woman, you choose to drag in somebody who practices deviling, which is in the definition of deviling, actually says a liar or lawyer who practices the legal profession. You create your own misery, ladies and gentlemen. So, but anyway, more on this extortion and the Hobbs Act. I think everybody should go read it. I'm just touching on a little bit of it, but here is what I find really great about the Hobbs Act. Form indictment. It's an indictment form that they give to you that you should all have printed out and stuck in your damn cars, your semi trucks, everything. The grand jury charges that at all times material to this indictment, victim whose property was to be obtained was engaged in described commercial activities in interstate foreign commerce and an industry which affects interstate foreign commerce, that on the date in the whatever month or district of the defendant, which would be the officer of the law, did unlawfully obstruct, delay, and attempt to obstruct, delay, and affect commerce as that term is defined in Title 18 United States Code, Section 1951, and the movement of articles and commodities in such commerce by extortion as that term is defined in Title 18 United States Code, Section 1951, in that the defendant, again, the officer's name, okay, did obtain and attempt to obtain tangible or intangible property. Tangible and intangible property. Did they try and ascertain a signature from you? That's tangible property, right? Did they try and ascertain a driver's license from you? Which under the Fourth Amendment, you're protected from incriminating yourself, right? The property of the victim with connection to commerce. With his/her consent having been induced by the wrongful use of actual and threatened force. What do they do when you won't comply? Oh, I'm going to take you to jail. You better do this or this is going to happen. Are those not threats, duress, and coercion? Yes, they are. Yes, they are. Violence and fear, including fear of economic harm. When they're threatening you with sitting in jail for 72 hours because we can hold you based upon probable cause, which is a color of law action, we can hold you for 72 hours. Are they inducing fear of economic harm to you and your family? Taking food off your table? Yes, they are. And that defendant did describe defendant's wrongful use of force, violence, or fear, all in violation of Title 18 United States Code, Section 1951. All you have to do is mention the fact, the Hobbs Act, your violation of the Hobbs Act. Did you describe the defendant's wrongful use of force, violence, or fear? Yes, you did. You mentioned the Hobbs Act. You mentioned it 3 or 4 times. You continue to mention it. You pull out this form and say, all I need you to do before I give you anything is fill this out properly and rightfully hand it back to me, and I'll have no problem doing what you want. It's a quid pro quo, baby. You want, I want. You put your money where your mouth is. You put your house where it is. You took an oath to protect, defend the Constitution and the people, furthermore, of this damn great nation, and you are gratefully in breach of your duty to we the people. And so now we're going to hold you liable. You won't find an officer, an agent, I don't care, CIA, NSA, FBI, ATF, DEA. You will not find one of them that will be willing to put their name on this piece of paper. I promise you. The grand jury charges that at all times... Okay, wait, I skipped ahead here. I get a little excited. Okay, this next one is an indictment form. Interference with commerce by robbery. Are they robbing you of your signature on the side of the road? Is that a commercial activity? Are they creating securities on the side of the road with you? Yes, they are. Let me answer that for you. That alleged ticket, traffic citation, is a securities instrument, all right? It's monetized. So they're creating commerce with you on the side of the road, and they're forcing you to do so, all right? And so here comes in some more of the Hobbs Act. That at all times material to this indictment, victims whose property was to be obtained was engaged in described commercial activities in interstate foreign commerce and an industry which affects interstate foreign commerce, that on the date in the whatever, state, figure this out, guys. It's not hard. District of whatever district you're in. And elsewhere, defendant, which would be the officer's name right there, the defendant, did unlawfully obstruct, delay, and affect, and attempt to obstruct, delay, and affect commerce as the term is defined in Title 18 United States Code, Section 1951, and the movement of articles and commodities in such commerce by robbery as that term is defined in Title 18 United States Code, Section 1951, in that the defendant's name again, did unlawfully take and obtain personal property consisting of described tangible personal property from the person of, in the presence of, owner or possessor of property against his or her will by means of actual and threatened force, violence, and fear of injury. Ladies and gentlemen, are these guys carrying weapons on the side of the road, forcing you to enter into contract with them under threat, duress, and coercion? Is there a possibility in the 21st century you can be shot and be completely unarmed? I mean, is it unreasonable to think that this day and age that an officer of the law knows better than to shoot an unarmed victim who they allege to be a criminal? Because you remember, everybody's innocent until proven guilty, right? So technically, unarmed people are victims, yeah? Immediate and future to his or her person, her property in his or her custody and possession, the person of a relative and member of his or her family, the property of, your name goes there, a relative and member of his or her family that is described, defendants attaining by actual or threat use of force, fear of injury. Go read the Hobbs Act, ladies and gentlemen. I'm not going to bore you with this stuff. I know I probably get boring and drawn out. Go read the Hobbs Act. All you got to do is justice.gov/JM/JM hyphen 9-131-000 hyphen Hobbs hyphen Act hyphen 18 hyphen USC hyphen 1951. That's all you got to do. Go look up the Hobbs Act. Go read it. Check it out. I'm telling you, this thing is a gold mine. It's a gold mine for liberation. Remember, you don't have rights if you don't know your rights. Freedom is not free, ever. Nothing in this world worth having, if you believe in earthly possessions of sorts, is worth having if it's easy to obtain. Freedom is very valuable, and it's not free. Get out there, do your homework, get after it. Keep studying, keep bringing more information to me. I have a class coming up soon on the name decree and the importance of the name and the doublespeak that they're using against you. So please stay tuned for that. It's coming. Still working diligently. I want this presentation to be factual, accurate, and undisputed. So the importance of bringing forth credible information with evidence and facts. It's so critical. The greatest disservice any one man can do is bring forward evidence or bring forth knowledge that he alleges to be knowledge that isn't based on any facts. And it's very detrimental to what everybody's trying to achieve, which is an ascension of the mind. So bear with me. Be patient with me, because the information I'm bringing forward to you is going to be hard-hitting, in your face, and factual. Cannot be debunked, cannot be beaten. All right? And that's what I want to do for you guys. So just bear with me, and soon we'll have a class on the name decree and much more. Thank you for joining me.